Margaret Cahirli Ganivig August Fulcherash Hogata Ara. In the first instance, I'd like to welcome this legislation. As the Minister has pointed out at the outset of today's proceedings, this furthers and refines the measures at European level to ensure that the state can tackle money laundering, can deal with issues surrounding money laundering and the financing of organisations like terrorists and illegal organisations, and it's tremendously important. As I've said in this context on a number of occasions, it's also important that this legislation is legible to ordinary people. And this is an amending piece of legislation. It amends not just the 2010 Act, but that 2010 Act has already been amended by the 2018 Act. So reading this document is actually incredibly difficult because almost every section amends another Act. And it means that for an ordinary person who wants to see what the law says, it is extraordinarily difficult to penetrate the dense nature of this bill. That could be overdone if we adopted a practice in these houses of passing consolidated legislation every time. Instead of amending, actually repass the Act, repeal the earlier one, and have one single version of what the law is on money laundering, anti-terrorist financing, etc. I mean, I say that a lot. I think it's something that we should be considering. I recognise that it creates administrative challenges, but I think that it would make our law a much more penetrable and legible corpus for ordinary citizens as well as for lawyers. As I say that as somebody who goes through it on a relatively regular basis. Mention has been made also, Minister, of the fine that Ireland has sustained as a result of the late passage of this legislation. I know the deadline for the passage and implementation of the legislation was a little over a year ago, on the 10th of January last year. Anybody with an eye on politics will know that perhaps politicians' minds were on other things at that stage in the process, but it is unfortunate that we are late transposing this, and I hope, as you have said, that it will enjoy a supported and fast passage through the House of the Oireachtas. I wanted to raise in that regard really just 3 or 4 points about the content of the legislation, and the first one is largely actually in the same vein of what Senator McDougall said about the implementation of this legislation and other AML, anti-money laundering legislation. There is a real danger with the implementation of these rules and regulations by commercial entities in this state that the bureaucracy goes into overdrive and they love to put in place measures that they say comply with the legislation, but we would all recognise go far beyond what the legislation actually requires. And this has been the case for a large number of years, even down to opening a bank account in terms of establishing your identity and proof of address, etc. The banks invariably require more forms of proof of address, more forms of identification than the actual anti-money laundering legislation requires. It's totally unnecessary. It doesn't make the system stronger. It doesn't stop people from money laundering, and it doesn't make it more difficult. I mean, these measures are important, absolutely, and it should be the case that you have to establish your identity, but not to the satisfaction of some bureaucrat in bank head office, wherever that might be, who's decided they're going to go one step further than the legislation already is. And there's a real danger that legislation like this becomes a charter for banks creating another barrier for people setting up an account, or indeed changing bank, shopping around, moving their account elsewhere, and using the competitive measures that the state is also trying to push from the other side of things. So it's important, I think, as well, that the message go out that there are onerous responsibilities as a result of this legislation, and banks and commercial institutions and designated persons and the other people mentioned in this legislation don't need to go beyond that. The Know Your Client provision that has been represented. I mean, yes, of course, banks should know who their clients are, and yet it seems to me that whenever I want to ring my bank, nobody knows who I am. The only person I can speak to is in a call centre somewhere, not actually in the branch where my bank is. So banks cannot have it both ways. If they want to serve their clients, that's exactly what they should do, instead of hiding behind legislative measures. The second thing I wanted to talk about was, again, that politically exposed persons, and I think that as Senator McDougall has pointed out, there are very onerous provisions in relation to people who are designated as politically exposed persons, and we shouldn't underestimate that. I too have received many forms from my bank, some of which I think ask me for extraordinary things. Given that they ask me to account for my income well beyond what the Revenue Commissioners might ask me to do if they were auditing me, for example, it seems quite unreasonable. I particularly want to ask you about the provision in Section 10 of the bill, which amends Section 37 of the 2010 Act and expands the definition of a politically exposed person to include an individual performing a prescribed function. I'm presuming that that intends that the Minister would prescribe that function. It's not clear to me where in the bill the Minister is empowered to do that. Perhaps that's already contained in the 2010 Act, but I wonder if you could just clarify where the power to so prescribe those functions and the power to, or how we're going to define the further expansion of that class of politically exposed persons lies. I also wanted to just point out in section 5 there's again an expansion in terms of designated persons, and in the same way the politically exposed persons have onerous obligations, designated persons do too, and I see that this bill will now bring in letting agents who are dealing with properties where the monthly rent is more than €10,000. That's in section 25 subsection 1 paragraph F, and art dealers in section 25 subsection 1 paragraph IC, where again the art is over €10,000. I don't have a difficulty with either of those provisions. I think for the vast majority of transactions they're at the upper end, and it's entirely appropriate that they would be pitched there. I wonder, however, if it might be worth considering index linking that €10,000 figure, so that if we don't have to come back here in 10 years or 15 years to revise that figure upwards to account for the fact that property or art or general inflation has meant that figure has brought a whole load of people into the net of designated persons who are not required to be there, and I think index linking might overcome that. I also welcome the slight relaxation again in section 10, which again amends section 37 on designated persons, of having to examine the background and purpose of transactions that are unusually large or complex, and the insertion of the words "as far as possible" appears to me to be a reasonable response to a very difficult obligation on them, and I think perhaps a measured response to the fact that they may have to do more than is reasonable. But on the whole, Minister, I welcome this legislation. I think there's a great opportunity for us, as you have said, to refine what the European Union does and we as a national government do and a national state. I think it's very important, and I support the legislation on behalf of Fine Gael and hope it enjoys a fast passage.